there's a risk that what you're planning to do might infringe intellectual property rights of someone else. And that's the key difference. That's really the problem at the core of accidents in both tort law and IP. But for our purposes, it's really at the core of IP accidents.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome to episode 6 of the 3rd season. On this episode, we're going to talk about an interesting idea. What if your responsibility on intellectual property infringement will depend whether you wanted or intended to infringe? What if there's a way to cover yourself against IP accidents? Let's see what our guest has to say about it.
My name is Patrick Goold. I'm a senior lecturer at the City Law School in London, where I teach and research primarily in intellectual property law. I say primarily, I guess I'm interested in the philosophy of law, and I'm interested particularly in the philosophy of intellectual property and the philosophy of technology. And as someone interested in legal philosophy, I am a pure academic. So I am an academic at heart. And I studied and grew up in the UK. It's where I'm from originally. But then I left the UK, and I guess my early career was in a few different countries, Germany and the USA, mostly the USA. And so after completing my PhD, I spent a number of years teaching and researching IP law at various US law schools, Berkeley, Chicago, Kent, Harvard Law School, before coming back to the UK to start work at City. And I joined in 2018, and that's where I am now. So that's my background. And so you asked what led me to write the book. Well, I guess it goes back to when I was a PhD student in Germany. And it was 2010. And I read a very interesting article written by a friend and colleague, Shyam Krishna Balganesh, called Foreseeability and Copyright Incentives. And that was just published in the Harvard Law Review at that time. That was a really interesting article. It basically said the copyright holder, or we give the individual copyright in order to encourage them to create. And what Shyam argued is that, well, then you should only give copyright protection against uses that the copyright owner could have foreseen, right? So, if you create a book and then somehow there's some sort of new type of use of that book, then and you could not have foreseen that when you created the book, then that could not have reasonably given you any sort of encouragement to create. You didn't think of someone using your book in this way, so how would you profit from that? Anyways. So I read this back in 2010, and I was like, this is interesting, because this is basically an idea which comes from tort law, this idea of reasonable foreseeability. And I was thinking, well, I wonder what other concepts and ideas come from tort law which could potentially improve intellectual property. We talk about intellectual property, we ask our philosophical questions about, is intellectual property really property? And I was interested in going a bit beyond that. I was thinking, well, here's this interesting article talking about tort law and how that affects intellectual property. I wonder whether there's something else in that. And that really started this process of thinking about intellectual property through a tort law lens, thinking about it through kind of a non-property paradigm. And that really was the start of it. And of course, as I think we'll get onto, that led to this idea of IP accidents.
It came from combining the idea or the rules from another realm of IP, outside IP. So another type of law, which is tort law. It's something very common law. Can you explain a bit further what is tort law, like in a sentence?
Well, I think the best way I can explain it is probably if we get onto IP accidents, because I'll be able to explain the tort law influence through that medium.
Perfect. So what is an IP accident? How do we get in that bus?
So IP accidents, that's the title of the book, IP accidents. All right. So what we're talking about here is accidental infringement of intellectual property. So I'll just give you a couple of examples of what I'm writing about or what concerns me. So Ed Sheeran has been in the news recently for he won at a very important copyright case in the UK recently. He's defending more in New York. So imagine you're a musician. You go into the studio, you write a song, you record it, and you think, yeah, that's a really good song, and then you publish it, and then someone turns up and says, actually, that sounds a bit too similar to my song. You must have heard it 20 years ago, and it's been percolating in the back of your mind for 20 years. And you've infringed my copyright in the song, right? That's not an intentional infringement. The musician would turn around and say, well, look, I didn't intend to do this. It was an accident. Or let me give you another example. You're a publisher, you're Cambridge University Press or Palgrave or, Random House, and you have an author and the author says, here's my manuscript. And you ask your author, do you have any third party material in it? Is there anything, any sort of copyright infringing material here? And they say, no, I can assure you that there's nothing problematic here. You publish the book. And then someone turns up and again says, actually, no, there is some copyright infringing material in this book, and we are suing you, the publisher, for infringing and publishing this book. Again, it's an accident. It's not something the publisher intends to do. And we could talk about this in patent law as well, right? So you come up with a great new idea, a new sort of technology, a new type of Wi-Fi, for example, and you start producing your product. And later it turns out that actually is protected by a patent. And again, you come back to say, look, this is an accidental infringement. It's not something I meant to do. It's not an intentional, deliberate, knowledgeable infringement. It is unintentional. That's what an IP accident is, or that's what accidental infringement is. Now, you mentioned about tort law. The reason tort law comes into it is, in layman's terms, are very simple terms and a bit oversimplistically, but that's what tort law is about. Tort law is the law of accidents. Not entirely, but that's a very, very big part of what tort law is, right? Tort law is, if I run you over in my car and break your leg, do I owe you any sort of redress? Should I pay you damages? Or if you come to my house for dinner and I have a faulty banister and you fall down the stairs because of it. Again, I didn't intend to cause you this harm. I have done it. I have caused you this harm unintentionally, but it's an accident. So that's the connection. What my book is about is the accidents in the IP world. And really the question is, what should we do about them? And to answer that, I take inspiration from a lot of the philosophy and economics of tort law, where they've looked at this sort of question in a different context.
What is the difference between the accidental infringement and the actual one?
Well, I wouldn't say accidental and actual. I would say just accidental and intentional, right? Okay. So intentional infringement is fairly straightforward. I would say the real difference between the two is the concept of risk, right? So imagine Letitia, you're an author and you write a book, and I look at your book and I open up the cover and it says copyright by Letitia, and I then just copy it and use some of your material without asking you. Well, it's pretty clear that I'm going to infringe your intellectual property here, presuming I'm taking a substantial part of your work. That's a certainty. I know you have intellectual property rights here. The difference between an accidental infringement is there's risk involved. So think again about the publisher. Let's take the publisher example, where you're Cambridge University Press or your Oxford University Press, Random House. and you have an author who comes to you with some material. You, the publisher, you're looking at this material and you think, there's a risk here. There's a risk that some of this material might infringe intellectual property. It's not certain, right? If it was certain, if you knew that, look, there's some infringing material here, then you would act differently. You'd find that person who owns the material, you'd ask for a license, but it's harder when you don't know these things for sure. There's a risk that what you're planning to do might infringe intellectual property rights of someone else. And that's the key difference. That's really the problem at the core of accidents in both tort law and IP. But for our purposes, it's really at the core of IP accidents. These situations come along where you're trying to do something good for the world. You're trying to produce a new song, a new book, but it's risky. It risks infringing the intellectual property rights of people who came before you. And what the book is about is how the law should respond to these situations. What should happen in cases of accidental infringement, if anything?
Yes, and some of this sample, one of the actors is always at risk of infringing. So a publisher in every book is in risk. So a producer as well in every song. So in this idea, will we find something different for those who are overexposed, let's say? Because it's not the same as you are an individual that can perhaps create at some point in your life or invent at some point in your life. But it's another view if you are in the business of either producing or an intermediary or facilitating or publishing these kind of creations.
Yeah, definitely. Some people, some organizations, let's take libraries, for example, do face instances of creative risk all of the time. That's part and parcel of being a publisher, of being a librarian, of working in research and development, is that your job necessarily involves the risk of infringing someone else's intellectual property rights.
So is there a way to shield oneself from this accidental infringements?
Well, yes. I mean, to a certain extent, there's ways to shield yourself. I guess what you can do, both as a user of intellectual property, of creative material, and as a producer, there are things you can do to prevent and reduce the risk of intellectual property accidents happening. So if you're a user of intellectual property material, you can do your due diligence. If you're let's use the publisher example again, you're a publisher and you have material that you think this might infringe someone's intellectual property rights, there's certain things you can do. You can search. You can look at the registers, right? Various copyright registers, patent registers. You can inspect the material, the good. In many jurisdictions, you'll find if it's a patented product, it'll have a patent number on it. There's virtual patent identification now, where it might give you a URL link to where you'll find the patent information. Or you can just do your normal sort of Google search looking for material, right? There's ways you can do, there's ways and means that you can employ to reduce your risk, to kind of reduce that unclarity. And equally, if you're the producer of copyrighted material or patented material, there's steps you can do to prevent people accidentally infringing your intellectual property. Right? You can register your materials. You can publicize, you can put notice on your materials. You can, Letitia, if you're talking about a book you have written, you would be, even if you live in a jurisdiction where you're not required to do this, it would be a good idea to say in the front cover, this is copyrighted by Letitia, and, this is where you can contact me. These are the details. That even if you're not required to do that by law, that's a very good thing you can do to prevent these accidents from happening. So, right, there are these things you can do to prevent the risk of IP accidents happening, both as a consumer and a producer.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property.
So it's about being mindful of in whichever scenario you are. So if you're the user trying to search and make use of the various tools of provided in the internet, also in IP offices where you can learn if something is already protected or if someone else has claimed rights over this work or product or invention. And from the other side, it's about making sure that you are yourself registering, protecting, and making the right legal processes to make sure that no one else infringes your intellectual property. And if they do, there are consequences because you have already obtained or secured the rights of that product.
Right. Yeah, it is about being mindful, as you mentioned. Although I guess my concern is more, how do we make people be mindful? Right. That's my my real interest. How do we incentivize people to be mindful? People are not always mindful, right? People are frequently careless. They will use material without doing their due diligence, for example. And equally,
and hoping for the best.
And hoping for the best, right? Well, that's okay. Sometimes that makes sense. You look at the risk and you look at the gravity of the harm and you decide for yourself whether that makes sense to be careful or not. You see that when, if we're thinking about tort law and accidents, sometimes you make an illegal U-turn in your car because you look and you think, well, there's nothing coming. Right. So we all make those kind of calculations. But I guess what I'm interested in is how do you get people to be mindful? How do you make sure that people do behave carefully? They try to avoid accidental infringements. But equally, how do you get intellectual property owners to play their part as well? Okay, just to give you an example, there was a good example some years ago where the University of Michigan wanted to digitize a lot of material of out-of-print books which were, printed many years ago, and they were orphan works, meaning they couldn't find the authors or the copyright holder for these books. And the University of Michigan put out a call. It searched, it tried to find the copyright holders, couldn't find them, put out a call, said, look, if you're a copyright holder, please come forward, just tell us. And if so, we won't digitize these books. We won't put them up online. But if no one objects, we will do this. And then they were planning on doing this, but after a certain amount of time, the Authors Guild in the US objected and said, well, actually, we have copyright in these books. We didn't object at the start, but now we've learned about this, we're shutting it down. Equally, just as much as you want users to be careful and to try to avoid accidental infringement, you want intellectual property owners to be diligent as well. And in that case, a diligent intellectual property owner would have responded to the university's plans a little bit earlier, to say, look, you've called for information. So here we're going to give it to you. So there's mindfulness, or what I would rather say carefulness, that both intellectual property owners and intellectual property users, and that we would like them all to be reasonably careful.
Yeah, makes sense. And I've seen that many times. The holder of copyright or IP waits until the project is out to start pursuing. So someone knows that the screenplay or there's something in the film that is infringing copyright of someone else's, and the copyright holder waits until the movie premieres, and then they pursue the legal action because they want to make sure that the product is already out or the work is already out, so they can use it as a best way to secure more profit or to secure a better understanding, easier, faster, or something like that. But in the case that you mentioned, I don't see it necessarily like that. But in other cases, I do see why they seem that they're not diligent, but they're waiting it out. To make it bigger. It's the same as, or the way to see if the product in the market is successful. And then when they see, this product is successful, then there's money here, so I can follow, I can pursue now this legal claim.
Right. And that strikes me as not a reasonably careful thing for an intellectual property owner to do. So, I mean, all of these are case specific and you look at the facts, but just as a general matter, those are situations where I think a diligent, reasonably careful intellectual property owner, or particularly when you're talking about they're in an interaction with a user who is unaware of the intellectual property, I would suggest they would do the reasonable thing to do in that case would be to inform them earlier rather than waiting for the user to make the use of the material and kind of commit themselves to that plan of action. Really what you want is the intellectual property owner to tell them at an earlier stage to try to put some sort of licensing scheme in place before the intellectual property owner has a position of power, in a bargaining power.
Yeah, makes sense. What do you propose for this kind of IP accidents? How can we regulate them?
Well, that really is the heart of the book, right? So the book introduces this the concept of IP accidents, right? And then asks, what should we do about them? What, particularly as lawyers, what should we do? How ought we to regulate them? So these cases are not new, right? Lawyers will know these usually under the terms of inadvertent infringement or unintentional infringement. These would be the terms that we usually use to describe these kind of accidents. I prefer to call them accidents because it highlights the similarity between these kind of accidents and the other kind of accidents we were talking about, right? So that if I run you over and break your leg in my car, the heart of the book is kind of this problem, which is, so if we're driving and I crash into you and I break your leg and I cause you some serious physical damage and monetary problems, I will not automatically be accountable for that. I will not necessarily have to pay you anything. I will not necessarily be held responsible in law. We have a system of negligence in these cases. Whether I'm liable, whether I'm responsible, depends on whether I was negligent or not, right? Now, if I was texting at the time or driving above the speed limit, then I'll have to pay. I'll be found liable because the society will have said, Patrick, you were pretty careless there. You're pretty negligent. You should have done better. But if I can show, well, look, this was just I was behaving carefully. I was driving at the speed limit. I was aware. I wasn't intoxicated. I behaved reasonably. That's the end of the matter. It's just one of life's misfortunes, unfortunately. And that is what I argue intellectual property law should move to. So currently we have a regime of strict liability. So if I accidentally infringe your intellectual property rights, I'm the publisher. Again, I put some material in my book. It doesn't matter if I work really hard to avoid the infringement, right? It doesn't matter if I come to court and say, look, I was really careful. I tried to avoid. I looked at the register, I made calls, I tried to find out if anyone owned it. It doesn't matter. You've used the material, you've infringed the rights, you pay damages, your business will be subject to an injunction. And I argue that intellectual property needs to move to a negligence regime, move away from this idea of strict liability, move away from this idea that every time you infringe someone's intellectual property rights, you should therefore be responsible and liable for damages and injunction. What I would prefer is for the courts to do what they do in other areas of tort law and to do in other areas of accidents, which is you look at how careful the defendant was. If they were negligent, if the intellectual property user was careless, then they should be liable, right? So if you're a business out there and you put in, you create a new invention, and you put in this invention into a product and you start selling it, and you didn't look at the patent registers, you didn't inspect products for any sort of patent information, you didn't do your due diligence, yeah, that's negligent. And if you do infringe someone's intellectual property, then you should be liable for being negligent. But if you can show, well, look, no, I did all I could. I didn't know in advance that this was protected by patent or this was protected by copyright. I really tried to avoid, the infringement. I did all I could. I looked into places. I did my search. I behaved just as you'd expect a reasonable member of society to behave in these cases. At that point, if you've behaved reasonably, that should be the end of the matter. You should not be liable for damages or an injunction. It's just one of those unfortunate experiences in life that, you have two innocent people here. You have the innocent IP owner and you have an innocent IP user. And you need to make a decision about which of these two innocent parties should shoulder the burden. And I say that if the defendant has behaved reasonably, they ought not to shoulder the burden of the infringement.
If they can prove that they have behaved properly, that they have done the due diligence, that they pursue every possible or reasonable scenario for themselves in according to whatever kind of business they're in. So it shouldn't go on them, or they shouldn't carry the burden of infringement because they try to avoid it, actively try to avoid it. But then it will be in detriment of the holder, of the IP holder.
Yes. So it would be, when you're saying a strict liability regime moving to a negligence regime, you are, talking about a less protective, a less strong form of protection for the intellectual property owner. That's true. There are a couple of points to mention in this. And keeping it simple, first of all intellectual property owners are intellectual property users at the same time, right? So if you're a creative individual in the arts, you are both producing and consuming intellectual property. So to the extent that you are, you get less protection for your intellectual property rights under a negligence regime, you're also more insulated from infringing other people's rights. So it's not really the case that you lose protection. You lose protection, but you also gain something as well, right? And the other thing to mention is that this proposal, or what I'm proposing, is really a compromise between two extremes, which are already on the table. So if we look at the literature, as I said, these cases are already known to intellectual property lawyers and scholars. We usually call them inadvertent or unintentional infringement, right? Now, lawyers have usually taken two lines to these kind of cases. The question is, what should we do here? One line is, say, strict liability, right? That's one approach that some theorists take. They say, well, once an accident happens, the defendant should just be responsible every time. Liability is strict, right? It is very strict liability. That's one approach. Here's the other approach: is no liability at all, right? If you accidentally infringe someone's intellectual property, there should be no liability that attaches. And you have some theorists who advocate for that line. Particularly, this is what's known in the patent world as the independent invention defense, right? So in patent law, some will argue that if you have independently invented a technology, and it just so happens that someone else already invented that, has a patent on it, you should have an independent invention defense, meaning that you're not liable. So those are two polar extremes, right? Strict liability, the defendant is liable, or no liability. There's no liability because it was an unintentional infringement of a prior right. A negligence regime is between those two polar extremes. It's saying, yes, the defendant is not always going to be liable. It's not strict liability. So in that sense, it is less protective than our current regime. But it's also more protective than the alternative, which is no liability. So if we take that independent invention defense idea, I would disagree with that line. I would not say if you have independently invented a technology, you necessarily get a free pass. You necessarily avoid all the patent consequences, to me, you can still independently invent something and be negligent at the same time, right? What I'd be interested is saying, well, when you independently invented this technology, did you do your due diligence? Did you look at the register before you commercialize this product? Did you try to find any intellectual property holders that might have had intellectual property rights? So you see, to the extent that it's less protective, it is not only beneficial to intellectual property owners as well, but it's also more protective than one of the very serious options on the table. So it's much more of a compromise than it might first seem.
It seems that provides greater balance, which is something that we're always looking for, especially in IP law, to make sure that we have a balance set of rights in both ends, so in the users and also in the creators, to make sure that in neither one is it's better or is in too much of an advantage of the other, because you need balance in order to have creations, to have inventions, and so on. Because without people making use of those works, you don't have any other one created, because that's how that's what you make of something. You learn, you surround yourself with whichever form science art you're dealing with, and then with that you start doing your own with what you already have consumed from someone else.
Right, and that's the whole idea. You know, if you're in this space, you're always going to encounter that risk. That's fundamentally the problem. That, you know, it's just like driving on the motorways. There's no way to do it without exposing yourself to a certain amount of risk. And if you drive a car, the risk is you might crash into someone, or someone might crash into you. In the creative space or the technological space, it's you risk infringing someone else's property rights. It's the intellectual property rights, and there's always this risk here. And as you mentioned, what we're trying to find is a position of balance where that risk is spread between intellectual property owners and intellectual property users. And that balance is not really facilitated by saying, users, every time you infringe an IP right, you will be liable. Equally, that balance is not encouraged by saying, users, you'll never be liable for accidentally infringing an IP right. The right balance is saying, well, look, we want you to behave carefully. And whether you're liable or not depends on whether you behaved carefully. And that's what we want to see from individuals and businesses and organizations, that they conduct themselves with the care that you would expect of a reasonable creative individual. That's by saying that, by building that standard into the law, that's how you encourage people to be careful. You know, by saying, look, if you're careful, you won't be liable. If you behave carefully, and you can prove to us beyond kind of the balance of probabilities that you behaved reasonably carefully, then you won't be liable. And of course, that encourages all actors to behave carefully, to actually search the registers, or if you're an IP owner, to put your stuff on the register or to put notice on your work, right? And ultimately, what the result of that is the number of accidents go down, the amount of licensing goes up. So it's about encouraging that sort of good, helpful care in the world.
Great. It sounds like a great premise and a great promise as well. Thank you so much, Patrick, for your time. Thank you for your research. Thank you for writing this book, IP Accidents, Negligence, Liability in Intellectual Property. We are hoping to keep reading you, keep learning from your research as well. And let's see where this great idea takes us. It's something that is worth pursuing, and that hopefully we may see it in a law someday.
I hope so.
We have reached the end of our episode. See you next Tuesday with a new guest and a new IP topic. Greetings from Switzerland.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.